Good evening, ladies and gentlemen, and welcome to the Licensing Subcommittee hearing. Councillor Cuthbert, Councillor Davies and Councillor Russell are forming the subcommittee, and members have nominated Councillor Cuthbert to chair the hearing. Councillor Cuthbert, can you please continue?
Thank you, Mrs. Borman. Could I ask everyone to note the fire safety instructions that on hearing the alarm you should leave the chamber via the double doors on the back, exit the building through the main entrance and congregate in the car park. Also, please switch off your mobile phones and turn any other electronic devices being used to silent. I would like to remind everyone present that this meeting is subject to an internet webcast recording where the proceedings are capable of repeated viewing. If you are seated in the public area of the council chamber, it is likely that your image will be captured by the recording cameras and result in your image becoming part of the broadcast. This may infringe your human rights, and if you wish to avoid this, you should leave the public seating area of the council chamber and move to the upper public gallery. Item 2, administrative function. Ms Tara O'Leary is our legal representative this evening. Please can you remind the subcommittee of its administrative function and explain the procedure to be followed?
Thank you. So just by way of introduction, I'm Ms O'Leary, I'm a barrister. I'm acting as legal advisor to the committee this evening. And my only role is to provide them with any legal advice they may need in reaching their decision. I won't have any other role in the making of the decision itself. So I will read a message which explains how the hearing this evening is going to operate. I would advise members and others present for this meeting that in dealing with the business of the subcommittee, members will be exercising an administrative function with a process similar to the Magistrates' Court. However, the proceedings will be informal. The rules of natural justice will apply. For the benefit of those present, I will outline the procedure to be followed in dealing with this agenda. Councillors Cuthbert, Davies and Russell are forming the subcommittee this evening, and Councillor Cuthbert, who's just addressed you, has been nominated to chair the meeting, and the chair will ask all parties to introduce themselves in due course. The licensing manager from Brentwood Council will then introduce the report in relation to this hearing. Members may ask questions on the report, and other parties may also ask questions. The chair will then invite the responsible authorities to address the subcommittee. Members and other parties may then ask questions of the responsible authorities. There will then be an opportunity for any other person who has made representations to address the subcommittee. The chair will then invite the licensee or their representative to address the subcommittee. Members may ask questions of the licensee and other parties may also ask questions. There will then be an opportunity for the licensing manager, responsible authorities and the licensee to make closing statements. Members will then leave the meeting to consider their decision. They may request legal advice during their discussion from me. When members rejoin the meeting, they will give that decision together with brief oral reasons, and the decision itself will then be confirmed in writing within 5 working days following the meeting. Thank you.
Thank you, Ms O'Leary. Item 3, declarations of interest. Are there any declarations of interest to be made? All good. Before I ask the licensing manager to introduce the matter before us today, could I ask all persons to introduce themselves, starting with the licensing officers?
Yes, Paul Adams, licensing manager. Just my role tonight is as the licensing authority. It is a separate function from Mr Leonard, who is the responsible authority, just to make that clear.
Good evening, Chair, members, ladies and gentlemen. I'm Dave Leonard. I'm the licensing officer for Brentwood Council, and I'm making the application for review in the capacity as a responsible authority. Thank you.
I'm Alan Wright, Environmental Health, and I'm making a representation.
David Carter, Environmental Health Manager. I haven't made any representation. I won't be addressing the committee tonight. Thank you.
Good evening, councillors. I'm David Daz, I'm counsel. I represent the company, which is the Wine Lounge Limited. I have a number of individuals from the business and the company to my left, but I would in effect be addressing you this evening. You'll notice also in the public gallery on the lower floor and the upper floor, there's around about 30 residents. I can confirm that every resident that's here is in support of the premises. Obviously, I'm only going to call one to give evidence.
I'm Zoe Borman and I'm a clerk this evening.
Councillor Vicky Davis.
Councillor Martin Cuthbert and Chair.
Councillor Will Russell.
I've just, to introduce myself again, I'm Tara O'Leary, I'm a barrister acting as legal advisor to the subcommittee tonight.
Thank you very much for that. Yeah. Yeah, that's great. Sorry. If you wouldn't mind introducing yourself, mate.
Yes, I'm Councillor Jane Winter from Ingatestone and Fryling Parish Council.
Councillor Hugh Rawson, Ward Councillor for Ingatestone, Fryning and Mount Nessing.
Thank you, Chair. I'm Councillor Leslie Wagland and I'm also Ward Councillor for Ingatestone, Fryning and Mount Nessing, in which the premises are situated. Thank you.
Lovely. Is there anyone else
I
speaking?
think the three people sitting on the back table are all the interested parties that are entitled to speak.
Lovely. If you wouldn't mind introducing yourself, you press the button on the microphone and introduce
Hi,
yourself.
my name's Glenn Barnes. I'm just a customer. Thank goodness the traitors aren't on tonight, otherwise there wouldn't be anybody here, I don't think.
We are John and Sherry Cavill. We are customers and residents in the village.
Lovely. Thank you very much. That's everyone? Fantastic. Thank you very much. We now begin. This is an application to review a premises licence for Lounge Wine Bar, Clifton House, 40, isn't it? It says 30, is that correct? It's 40, isn't it? 40 High Street, Ingatestone, CM49EE. Mr. Adams, will you introduce the matter, please?
Thank you, Chair. As you said, an application for the review of the premises licence at the Lounge Wine Bar was received on the 3rd of December 2025. The application came from Mr. Dave Leonard in his capacity as responsible authority on behalf of the licensing authority. A copy of that review application, together with his supporting appendices A to H, are attached at Appendix 1. The Lounge Bar, as you know, is situated on the High Street, but we've also provided a copy of the current premises licence, together with some OS street maps, so you can better identify the location, and that is attached as Appendix 2 to the report. The application has been consulted upon in accordance with the Licensing Act, and following that consultation, a representation was received from Environmental Health, from Mr. Alan Wright, and he is here tonight, and his representation is attached as Appendix 3 to the report. We've also received 6 representations received in support of the review from residential households within the general location to the premises. There's also been 3 further representations received from local councillors. 2 of those local councillors are here tonight and they can speak to their representation. All of those representations are attached at Appendix 4. But we have had apologies from 3 of the local residents who didn't feel that they could attend tonight because they felt intimidated by the process. You have been circulated, both the licence holder and yourselves and the other responsible authorities have been circulated some additional documentation in support of the representation from Melissa McLearney. I won't read that through because I know you've had copies of that and I'm sure you would have read that, but if you want me to read any of that, I'm happy to do so. As I say, all those applications are there at Appendix 4. We've also received 4 representations in support of the Lounge Wine Bar, and these have been received and redacted copies of those have been provided at Appendix 5. In addition to that, there have been some documentation supplied yesterday by the licence holder's representative, and again that has all been provided to yourselves and the other responsible authorities. I'm sure the licence holder's representative will take you through that appropriately. Contained within the report, there are references to our local licensing policy. That's at section 4 of the report. And there's also details around relevant sections of the Secretary of State's guidance under section 182 of the Licensing Act. Again, I won't refer to those in detail, but that's included in your report. I think, Chair, unless there's any other questions for me at this stage, I think that's probably all I need to say, as most people here are represented or have provided their written submissions.
Thank you, Mr Adams. Do members have any questions of the licensing manager at this time? Are there any questions from any other parties for the licensing manager based on what's been said? No. Councillor Gordon, you will get an opportunity. Is it directly based on what the licensing manager said? You will obviously have an opportunity to speak.
Can I just ask whether we'll be hearing any of Melissa McKinney's letter that she has sent in?
Mr Adams.
The letter has been provided to members and on all those concerned. I don't propose to read it out aloud unless, Chair, you wish me to do that.
Mr Dads.
Chair, the maker of the statement's not present. You've read it. I don't think there should be any more than that. And if the maker of the statement's not here using the principle of East Gwent, you may attach little or no weight to it, but I'll address you to it when it comes to it. But no one else should be speaking on its behalf.
Thank you, Mr Dads. I think I'm happy anyway. So yeah. So thank you, Councillor Gordon. We will now hear from the review applicant, Mr David Leonard, Licensing Officer on behalf of Brentwood Council.
Thank you, Chair. This relates to an application seeking a review of the premises licence under the Prevention of Crime and Disorder and subsequently public nuisance licensing objectives. In brief, it's over a 2-year period, and despite repeated efforts to work with and educate the management, they have strayed from the operating to the terms of the conditions of their premises licence on too many occasions for any further verbal or written warnings to be a consideration. On the 18th of October 2025, and despite receiving and acknowledging a 10 counter notice, the management blatantly operated otherwise and in accordance with the terms and conditions of their premises licence. These breaches have been accompanied by public nuisance complaints being received, and the apparent lack of sound attenuation system in the place at the Lounge Wine Bar has led to regular public nuisance complaints being received. A copy of the premises licence, current licence issued on the 2nd of October 2024, together with OS maps, is attached to my report, and it's also attached, I think, on the licensing manager's report, just to give you a location on it. There's no doubt about it that the management have been in dispute with several of the neighbours from the very outset of applying for the premises licence variation in June 2023, which effectively the venue changed from being a limited capacity of 24 persons for the purpose of cheese and wine tasting, with a 10 p.m. close, to a wine bar hosting parties and live recorded music until 11 o'clock, and sometimes later, extending with the use of temporary event notices. A timeline of premises, the licence that has shown the evolution of the licence from Ingatestone Wines in 2020 through to the current licence is at Appendix B. As I said, with relation to that, you'll see that there's an awful lot of paperwork in here, and I do apologise if it's meant a lot of reading, but I think it needed to have everything in there so you've got the full picture. This is not a one-off issue, and it was a situation that has put us in no other position than actually to put in for a review, so this can be resolved, hopefully pragmatically, to ease the concerns of any petitions or anything like that. I'm not seeking a revocation of a licence, and indeed on a number of occasions I've attended the premises in the daytime, which is more than I should need to have to, which explains the complaints we get, but they've been run very, very well, and it looks very, very well supported, and I'm sure it's an asset to the community. So I'm not seeking any revocation or anything like that. I'm hoping that the continued little niggles and breaches that have occurred over 2 years can hopefully be resolved with all the statements that come in today, and hopefully we'll get a result that everybody will be happy with. In relation to this, as I said, this has been going on for a couple of years now. So as I said, if you look at the licences, Appendix 2, which is Appendix B, which is the timeline, as I said, that explains how an off licence has evolved to an on licence, has evolved to a wine bar, and this was information I had to put towards the planning department, who had their own separate issues and complaints received, and they were dealing with that. So again, it's just to explain and help everybody to understand how this has evolved. Certainly on my very first meeting with Mrs Bell, when they first took the licence, we went above and beyond, myself and Simon Barnes, who was the police licensing officer at the time, to try and explain and help them through the licence. We understand what they were trying to achieve. Obviously, by the name Lounge Wine Bar, it was going to be a wine bar. And again, through the communications and emails and letters, we've tried to work as best we can with them to try and help them succeed with their business. If we follow through on the index thing there, obviously the incident timeline is Appendix C. Appendix D is correspondence and written warnings. Again, as I said, there's a lot of paperwork going through here. In an ideal world, I wouldn't have wanted to put everything through, but I think again it explains that I've tried as many times as I can to get the points across. As I said, some of the complaints have been a little bit on the petty side, I won't deny that, but as I said, I deal with the premises licence and the conditions attached. I'm not there to deal with the environmental health issues or the planning issues. But again, once complaints are brought to my attention, I'm required to deal with it. That's obviously on behalf of the council, my colleagues, and obviously having dealt with the Bells for a couple of years now. As I said, I've always tried to get on with them, and I'd like to think we have generally got on with things. Obviously, I'm sure that I'm not on their Christmas list now, but obviously, no, and indeed with that, as I said to you, obviously when trying to deal pragmatically with these things, it's very clear they've got a very low opinion of the council, both the environment, health, planning and whatever. So as I said, this has been a culmination of incidents and complaints received over a period of time where something had to be dealt with. Now in regards to this, I've poured, in the early days, which again was when the licence was first granted in 23, there was a number of complaints about a back door being left open, and some of them weren't the greatest in the world, and I went where I could to deal with it by means of a verbal warning or whatever, because as I said, I appreciate the Bells are trying to run a business, and we were trying to work with them on that. As we've carried on with regards to this, as I said, obviously there's a lot of written warnings or correspondence there, where on each occasion I have explained to them if there's any, if they've got any problems with that, we are here to help, but I also recommended that they seek the guidance of a professional licensing agent or solicitor, and I'm sure had they done that at the outset, we wouldn't be where we are now. As I said, when you go through all the letters, but they all come back and say, right, put it in the hands of solicitors or thing, and clearly from what was happening after that, they weren't, because they weren't operating to the guidelines that would really need to be followed. So in respect to that, we've worked through a stage where we got to the 10th of October 2024, where again I operated this with a TACO van that went out the back, again received a few complaints, but looking at the CCTV following the incident and the complaints received, it was clear there was a breach of condition 1 of Appendix 3, condition set by yourselves, about the premises keeping the back gate and outside area closed after 8 o'clock to customers. So again, on that thing, it was an isolated incident, and I know the Bells were trying to expand on the business, and it was dealt with by way of just a verbal conversation, and it was kept on file. As I said, we're not looking to hammer them down in any way, shape or form, but again, the lesson was learned, and I think they understood that, and then from there on in, I believe they were using a kitchen to deal with it inside the premises rather than having a TACO van outside at the back. Following on from that, Going through the TENS history, again, looking on history, there's a number of TENS have been applied for. Most of them have been late applications, and there does seem to be a misunderstanding or a lack of understanding on how the process works. On a number of occasions that have been rejected, they've asked for their money back, and it's been explained that it's an administration process, we can't do that. But again, we've tried to work with them in regards to that. On the 12th of April 2025, there was a temporary event going there, and on that particular night in question, I was out on late night enforcement duties along with Mr. Wright from the Environment and Health and Mr. Simon Barnes from the police licensing team. We went along there, as you've seen on the information on that one. In my opinion, it was noisy. We did have a conversation with Mr. Charlie Bell. I'll go through on that, but again, explaining the issues that were in regards to that. Again, that is highlighted, or it's put in extra detail at Appendix E, and we go in quite detail with that. Sorry, Appendix G is the 12th of April incident. So we've got Appendix E is the 10th of October, a breach. Appendix G is the temporary event notice on the 12th of April, which is just my evidence of the fact that, in my opinion, it was loud. There was a DJ that was in the front of the premises which is a glass window with glass doors, no lobbied area. They were open to let customers leave at the end of the night, and there just wasn't the sound attenuation. So, in my opinion, it was noisy, and there were noise complaints received as a result of that. We were confronted by Mr. Charlie Bell on that occasion, asking what the problem was, at which point there was a male that had staggered out the premises and again relieving himself up against the wall in the entrance there, which Mr. Bell dealt with. So that was that incident there. And then we culminated with the event which really has been the catalyst for all of this, and which we can't deal with by way of verbal warning or any more letters of warning, is the event that occurred on the 18th of October 2025. In respect of that one, where an application was made for a temporary event notice on the 6th of October. Let's get through onto that. And in respect of that one, the temporary event notice was, there was an objection or representation made by Mr. Wright. In that respect of that, a counter notice was sent to Mr. Bell. On the 10th, the objection was on the 10th of October. Mr. Bell acknowledged the counter notice on the 13th of October. It's made very clear that the temporary event notice hadn't been acknowledged or approved, and the event still went ahead. My understanding there, Mr. Wright was working that night, so I'm sure he can elaborate on that. But as a result, the party carried on past 11 o'clock, past the time of the premises licence, without a TEN in place, which means that there's a breach of the licence under Section 136 of the Licensing Act. Now, just following through on that, if I get to Appendix H. This culminated really with the events on the 24th of October, where I attended the premises with Senior Police Licensing Officer Mr. Gary Burke, where I met with Mrs. Julie Bell and Mr. Charlie Bell. The DPS, Mr. Michael Bell, was unavailable on that occasion, so I was dealing with his wife and his son. Where I introduced Mr. Burke to them. This is the first occasion they dealt with the police licensing officer, the new police licensing officer. And obviously I explained why we were there. Mrs. Bell straightway said we had a 10, and I said, no, you didn't. Mrs. Bell and son explained they received the objection from Mr. Wright but didn't have any refusal letter. I explained that the counter notice procedure and showed them a copy of the counter notice on the iPad that I attended the premises with. So I showed them that. Both Mr. Charlie Bell and Julie Bell said, well, we'll have to take a hit on that, we didn't know. Both continued to complain that they were naive to the process despite having previous tenders rejected, and I pointed out the offence under 136 of the Licensing Act to carry a licensable activity on or from any premises other than under and in accordance with an authorisation. When we asked to view the CCTV of the event from 10:45 onwards, we watched it up until the arrival when the police were called to an incident just before midnight. The recording clearly showed licensable activity continued after 11 p.m. and alcohol continued to be sold throughout the course of the night in breach of the terms and conditions of the premises licence. The purpose of viewing the footage was, up to the arrival of the police, was to ascertain whether a fight with glasses had been smashed had also taken place, which had been claimed in a call to the police. There was no evidence of that at all. As I said, so viewing the CCTV is not just about trying to find evidence of offences, it's also trying to validate allegations that have been made. And on that occasion, there was no evidence that any fight took place or bottles being smashed, and I would have suggested that looking at the camera outside, if anything had happened outside, those that were outside smoking would have been distracted by the noise or whatever. There was none of that. So in fairness to the allegation there, I couldn't find any evidence of that. Following on from that, we requested to view the CCTV footage. As I said, we looked at that. There was also an incident on the 2nd of October where an incident occurred regarding a 14th birthday party. And again, I think the police were called to an incident that happened outside there. Again, viewing the CCTV on that instance, whilst there was a 14th birthday party going past there, there was adults and family there, and there was no evidence of any incident or disorder occurring in the lounge bar or as a result of the lounge bar's event. So again, the CCTV isn't all about just proving one thing or another. In regards to that, the CCTV that we did seize is available for viewing should there be any challenge to that, both for the event on the 18th of October, should you wish to see it, and also on the 10th of October 24 with regards to the taco van. As I said, on both occasions, the Bells were quite honest and upfront that they'd done this in naivety, and as I said, the CCTV would just go to show that. So in that respect, should you need to see it, but again, I provided an awful lot of paperwork here. I appreciate it's a lot of reading, a lot of CCTV. If it's not challenged, then there'll be no need to show the CCTV. But that's basically my role in this, and this is what we were saying with regards to the visit on the 23rd. On this visit on the 24th of October, my role with the police licensing officer there was to look at the allegations that have been made in relation to the offences on the 18th, alleged offences on the 18th of October, and that's what we did. Despite issues being raised about environmental health and planning issues, that is not my remit, and I was dealing with conditions of the attached to the premises licence and whether they were being complied with. Also in relation to that, although beyond Miley, the incident logs and training records weren't available for viewing against the condition of the licence, but again, that's being petty, and as I said, it's not something I had an issue with. My understanding was it's all kept on electronically on the system and would have been available for viewing, so it wasn't an issue for me to deal with that. In relation to this, as I said, as we carried on with regards to this, Charlie Bell and Jude Bell did continue to make references with regarding to environmental and planning matters, and I obviously said that wasn't to do with me. Charlie Bell then commented on a resident living above the bar and claimed that his mum had helped her experience with domestic distress in the past, and stated she replays us with complaining. We can hear her take a shit up there. Excuse the French on this. I replied, if you can hear her take a shit, what do you think she can hear when you have a party? That's the only reason I say this. I can't put it any clearer. That's what was said to me. Obviously, he didn't reply to that. The completion of my inquiries, I explained what would be formally requested. We'd be formally requesting the CCTV, which we did receive. Obviously, following all that, that's basically the evidence with all regards to those things, Chair. As I said, I apologise for the full detail with regards to this, but in regards to the application and what I'm trying to achieve, hopefully all the information, should there be any challenging, is there. I've extended on the letters of notification. There's no doubt the neighbours are not going to get on. And that's just one of those things. Obviously, what we're trying to look at here is trying to get a pragmatic solution to carry on. As I said, there's no problems with the way the business is run during the day. My understanding is that the Bells are now looking to go towards a more bistro or restaurant thing, and that might be a good solution to it all. As I said, I'm not looking to seek a revocation. I'm looking for anything too severe with regards to that. But obviously, once putting this in, the application for a review also gives the opportunity for anyone else that's got issues with it, both for and against, to have their say. And I'm sure a majority of those putting in a petition and putting in some letters of support have got every reason to do so. And I'm sure what they do during the day is absolutely fine. As I said, my evidence of visiting there during those times, I've got no issue with that. Obviously, summing up with regards to this is what do I hope to achieve from this? I've asked for the review. What would I ask from this? Normally, it would be a case of, well, we want something specifically done here. Now, in regards to this, there are other complaints and issues that are arising from other people, and to ask for anything specifically to be attached at this stage, not knowing what else is going to come out from this hearing, was probably not appropriate at that time. As I said, certainly with regards to this, it's often considered that it's the last option and that all other means of resolution by way of education and or mediation have been unsuccessful, and unfortunately over a 2-year period that has been the case. And whilst the incident on the 18th could have been dealt with by way of prosecution, it's my hope that the review of the premise licence will be more pragmatic to address the issues and concerns that appear to be repeating themselves. I mean, based on the outcome of all the information that's put before you at the end of this evening, it might be that you might want to consider a change in the management to ensure the promotion of the compliance of existing licence conditions apply, in respect of maybe the DPS, who can't always be there because he's got another job. You might want to consider disapplying the Noise Act exemptions with regards to the music and playing music late. That's something I'm sure the Environment and Health would probably consider or answer questions on. Probably the most important thing, again, just using experience of this, is that at the moment the licence hasn't got anything to do with a noise management policy, and maybe a noise management policy that's a comprehensive policy and that's been supported with the environmental health might be something that moving forward will allow the premises to comply easier with their events and activities, and hopefully everyone getting a lot happier and more peaceful. Hopefully I've put across everything that needs there, Chair. I do apologise, as I said, it does go on. I'm trying to make sure everything's in there, and I do apologise for the language that come out on that, but that's how it happened, and it probably sums up everything about the noise complaints over 2 years. Thank you.
Thank you, Mr. Leonard. So whilst I appreciate that may well have been how the incident played out, there are children in the room, so if we could ask everyone to be considerate and curb the language, we may need to describe things in other ways, but yeah, if we can bear that in mind. Yeah, thank you for the detailed information. Do members have any questions of the review applicant? Councillor Russell.
Thank you, Chair. From the outset, you said that the family had a low opinion of the council. I think that's probably shared by many of the residents of the borough, particularly when such language is used by officers. I want to ask, please, what monitor equipment did you have when you was investigating these? You obviously, you said that in your opinion it was loud on a certain occasion. Did you have a body cam, decibel meter? What recording equipment did you have to evidence this? Thank you.
Sir, that's not my role. I'm not the environmental health officer. I don't deal with the recordings or monitoring of environmental health matters. In respect of my comments on the events for the 12th of April, it was just my opinion that it was very loud. In regards to Ingatestone High Street being a high street like any other thriving, busy high street, it's not quite the same as Brentwood High Street, for example. There's echo chambers and whatever. It does resonate. In my opinion, it was loud.
Okay, I just take that was your opinion, and being a wine bar, there's obviously going to be some sort of sound coming out in a busy high street. You mentioned someone that was relieving themselves outside, and I guess you're talking about urination. How would, from your opinion as a licensing officer, how would the licensee police such activity outside of their premises?
In respect of that, there's no real powers. I mean, premises that would employ door supervisors can only deal with what's going on inside their premises. And whilst it might be a public duty to assist someone that might be in trouble outside, there's no powers to deal with any of that. On this occasion, Mr Bell, as soon as I pointed it out to him, he strode across the road, dragged him away from there mid-urination and pushed him on his way. It was the immediate way to solve the problem.
And lastly, you mentioned that the benefits of CCTV and how they can work, on behalf of the licensee when claims are made that, events happened and clearly they did not. I think that's just worth bearing in mind when we start talking about credibility of witnesses and the sort of stuff that we hear, hearsay, he said, she said. So it's just worth bearing that in mind. Thank you.
Thank you, sir. Yeah, that's exactly it. As I said, the CCTV on the occasion we've looked at it was worked both for and against on certain applications that have been argued. Thank you.
I'd like to hear the evidence of others, Chair, before I ask any questions. Thank you.
Okay, thank you, Councillor Davis. I just have a couple of questions. Just for clarity, can you explain what the possible implications of some of the breaches are? For example, ignoring the TENS notice, whilst it's been described as naivety or things like that. What are the actual implications of not complying with Councillor Dad? Sorry, Mr. Dad.
Sorry, yes. Could I raise a legal point, please, here at this stage? And perhaps, obviously, you can revert to your lawyer. In relation to the allegation of a criminal offence under the Licensing Act, that would be sub judice. This is not a regulatory committee insofar as to attribute blame or criminality. If it's an ongoing investigation, it's still live, there's CCTV obtained, it wouldn't be appropriate to discuss it here because obviously it's subject possibly to a potential criminal investigation, certainly up to, or a prosecution up to 12 months. So it wouldn't be appropriate at this stage. And I do know that my client would raise a number of defences in relation to that matter, evidence and information received by the council about wishing them good luck for the 10. So I think it's not as straightforward, and it's not here that we should hear that. That's a matter in a court if the council thought it was in the public interest to prosecute.
Chair, I can just clarify. As I said, I think I pointed out that we didn't think it was in the interest to prosecute, although that was an option. It was something, as I said, obviously this doesn't resolve an ongoing thing for 2 years. Hopefully this will get everybody together with a view that all issues can be sounded out and hopefully a sensible solution resolved. As I said, we're not trying to screw them into the ground or anything like that. We're just trying to get a sensible result at the end of this that's gone on for far too long.
Mr. Dad.
Chair, I'm not suggesting that the responsible authority is trying to screw anyone to the ground. Let me make it absolutely clear. This is a responsible council, respectable council, and I respect the authority of the licensing authority and you as members, and you will act fairly for all parties. The licensing authority have just said that it's not in the public interest to prosecute in relation to the alleged breach of the 10. Therefore, we shouldn't be discussing it. In my view, is that we could raise a number of defences, which we don't have to now because obviously they're not going to prosecute. I think it's there. If there is no crime, therefore there's no undermining the licensing objective of crime and disorder, therefore it shouldn't be discussed.
Okay, Mr. Dad, thank you. I guess, yeah, sorry. Yeah, if I can hand it over to you, if you don't mind.
I mean, I think there is a factual allegation, as it were, on behalf of the licensing authority that there was activities taking place outside the scale of the operation schedule. And it may well be right to put aside the question of whether or not that's a criminal offence, whether or not there's a defence to it. You've had a clear statement of intent from the licensing authority that it does not intend to bring a prosecution, but you can decide for yourselves whether or not you think it is right to at least consider whether or not there was an operation outside of the schedule of licensable activities in terms of what did or did not happen. And whether any of the licensing objectives are undermined as a result of that, whether or not it's crime and disorder or some other licensing objective.
Okay, thank you very much for that. Mr. Dodds.
I know that that's a provisional advice until everyone's had an opportunity to respond. I welcome the comment at the end that we are here to, and you are here to determine whether there was an undermining of the licensing objective. If there's no undermining of the licensing objective, then there's no undermining the licensing objective. You heard that there was a complaint made regarding a disturbance outside. CCTV factually has been, we've heard in evidence, was viewed. There was no such crime. Therefore, there is no other evidence of any undermining licensing objectives, whether it be crime, disorder, public nuisance, or any other matters arising on that day. So therefore, even though it suggested that a temporary event or activities carried on otherwise than in accordance with a licence, there is no intention by the licensing authority to, or in the public interest, to prosecute. Furthermore, you've heard in evidence there was no undermining licensing objectives. I'll just say this so your lawyer makes a note of it, is that what we are discussing, if it is a 10, that's a separate authorisation which is made to a user, which is separately regulated under the Licensing Act 2003. What we are dealing with is a licence which is authorised under the Licensing Act to the company, and the company's authorisation stops at 11 o'clock. Thereafter it becomes the user. So there is a separation between the premise licence holder. Under section 52 of the Licensing Act and under the guidance under chapter 11 of the guidance says you can only seek a review of a matter arising in relation to the grant or activities of that licence. Up to that time, up to 11 o'clock is the licence. After that was the 10. You've heard that there was a misunderstanding with the 10. The council's not going to prosecute it. How far we go with it, I don't know, but I'm just raising it. We've got to be careful about suggesting there's criminality when it's not gone through due process. And we have a due process system here. Everyone is innocent till proven guilty. And furthermore, this authority, and you sitting today as a licensing authority, are not here to attribute blame or find innocent or guilt.
Thank you, Mr. Dodds.
Is there anything you'd like to
I'm happy with how things are at the moment. Thank you very much. So do any other parties have any questions of the applicant at the moment? Mr. Dodds.
Yes, I have a number of questions for you, Chair, if I'm permitted.
Please do.
Thank you. Mr. Leonard, could you just perhaps just clarify a few points for me, please? Thank you. Can you tell me, in the last 12 months, has there been any warning letters in relation to any specific breach of the premises licence, please?
Sorry, I don't recall writing one out. As I said, any notifications I've listed in the appendix. So if there's not one in the last 12 months, there's not one.
Thank you. Can you tell me if there's been any PACE interview, although it looks like you have been doing records of interview, but is there any actual PACE interview in accordance with PACE in the last 12 months?
No, there's not.
Can you tell me, other than the visit that you made on the 12th of April, which is outside of the licensed hours, but subject to a temporary event, can you tell me if, have you in the last year attended the premises any Friday or Saturday night, please?
No, I haven't.
Do you accept that on the 12th of April 2025, when you attended and had an opinion regarding the noise, that was in relation to the temporary event granted to the individual user and not the premise licence holder, who's a separate corporate identity and individual or company?
Sorry, I didn't get that. I think the answer is I've got no issues with it. It was operating on temporary event notice. It wasn't breaching any conditions.
But you accept that the temporary event notice, the user is separate and different to a premise licence holder, here being a company?
That's correct.
Can you just confirm, I think you answered it in relation to the councillor at the end there, I think Councillor Russell. Do you have any professional qualifications in relation to public nuisance or noise?
No, just 30 years plus of a police officer and 25 years experience as a licensing officer dealing with these issues on a reasonably regular basis.
Are you saying then that you have an opinion, a professional opinion, valid in relation to public nuisance?
I believe my experience gives me the right to have my opinion, but as I said, obviously Environment Health will deal with something in any action capacity.
As the licensing authority and you acting as the responsible authority for the licensing authority, can you just clarify so the public know and the premise licence holder, you're not there to investigate police crime, is that right?
No, that's correct.
Chair, I have no further questions. Thank you for allowing me to ask those questions.
Excuse me. Thank you, Mr. Dodds. Are there any other parties with questions for the applicant? No? Okay. We'll now hear from the responsible authorities. Mr. Alan Wright, Environmental Health Officer on behalf of Brentwood Borough Council. Mr. Wright.
Thank you, Chair. My representation is made relating to the licensing objective, prevention of public nuisance. I'm the district officer who covers Ingatestone. The Lounge Wine Bar is situated at Clifton House, 40 High Street, Ingatestone. To one side there are commercial premises including shops with residential property above, and to the other side there are further residential properties. There is also one residential property directly above the Lounge Wine Bar and more to the rear in Clifton Terrace and Woodland Close. Clifton House was previously Ingatestone Wines, which was an off-licence, then an on-licence, and more recently the Lounge Wine Bar. The performance of amplified music, particularly where this has occurred outside of the normal operating hours of the premises, i.e. during but not limited to a temporary event notice, has resulted in most of the noise complaints that we have been received to date. This does exclude the rear courtyard noise, which was noted at a previous licensing subcommittee hearing on the 2nd of August 2023. Since the opening of the premises...
Sorry, Mr. Wright, 1 second.
Sorry, I do apologise, Chair, but I think it's only right. I won't interrupt you.
Sorry, do you mind holding your mic off for a second, and you can turn on.
Yeah, thank you, Chair. Thank you. I don't want to interrupt the officer, but I feel that I need to protect my client's interest to make sure they get a fair hearing. At page 243 of the agenda, Appendix J, is the memo and the representation made by this officer. He's just referred to something that is not included within that representation. Of course, he can amplify anything that is written, but can't add anything new. If he wishes to add anything new, he should have sent it in advance. So I'd ask him if he could stick to page 243, amplify only, and add no new information that hasn't been disclosed to the company and me before this hearing, so as to make it fair, in accordance with the law.
Mr. O'Leary.
I believe there is evidence of the license decision. Well, certainly the license granted in 2023 is in the bundle and is before you. I think if Mr. Wright broadly needs to focus on amplifying his own submissions, but I think commenting on other material in the bundle is not prohibited at a hearing by a party who's making representations.
That's incorrect insofar as if there's a written representation in relation to review, you write it within 28 days. If you want to add anything in addition, you can obviously serve it in advance of today's hearing. You can amplify what you've written, but can't add anything new as a matter of law.
So, sorry, yeah, we're getting a bit of obviously conflicting information, and we could.
Yeah. I mean, the procedure is ultimately in your hands.
Yeah.
It may well be that if if Mr. Wright is simply summarising the background rather than giving evidence or representations on new information relating to whatever happened in August 2023, you might find that it's up to you whether you want to decide to allow him to do that or whether that's helpful to you.
Okay. Well, I mean, if we can, Mr. Wright, I don't know if you can try and keep it and to amplify your representation. That would be beneficial. And yeah, if it's very broad, then fair enough. But yeah, no additional information. If you see what I mean.
Okay.
Thank you.
Right. Yeah, I'd like to refer to an email received from the Lounge Wine Bar Director, Mr. Michael Bell, on the 31st of October 2025.
Chair, if it's to the, that's not Chair, that is not appropriate unless it's in the representation, Appendix J. If he wanted to refer to an email, he could have sent it to me this afternoon before the hearing started and gave me the courtesy. If not, then we need to have an adjournment now so that he can show it to me and I can then say whether I object to it or not. The regulations are very clear. If there's anything new or evidence adduced at the time of the hearing, you need consent of each party and all parties involved. I don't give my consent at this time for any new document being handed up that hasn't been given to me in advance, because we want a fair hearing.
Yeah, I think it's correct to say that anything that is entirely new and is produced at the hearing in accordance with the regulations does need to be admitted with the agreement of all parties. There are a number of options that the panel would have, one of which, of course, is the immediate take a break for 5 minutes, allow Mr. Dadds to see any new material that one of the parties would like to hand up, discuss whether there will be an objection. Potentially, if necessary, a hearing can be adjourned if material is so important that you need to consider it, but without prejudicing the interests of another party. But I think if it's, I think amplifying by way of simply making reference to something that is somewhere else in the bundle is not necessarily entirely new or prohibited. And I think that's what I was trying to, the point I was trying to make with my previous advice.
Okay, yeah, Mr. Adams.
Just for clarity, I believe that the document that Mr. Wright is referring to is already in the bundle. Maybe we should give Mr. Wright the opportunity to identify where in the bundle is referring to.
Okay. Yep. If you wouldn't mind, Mr. Wright, if you can advise where that document is, and so everyone can find it and review as required. do you,
Yeah, sorry, Chair. I think in my appendices you'll find in the timeline of letters written, Mr. Wright's emails. I think I've even got some police emails I put in just to cover everything, the letters of complaint and worries, things that came through. So perhaps Mr. Wright's letter is in that little bundle.
okay, so we don't, so, sorry, Mr. Leonard, would you mind turning in?
Sorry.
No.
I'm not trying to be obstructive for obstructive's sake, but what it is that because I don't know what was going to be said, and because I know I'm just looking at this, I'm saying, well, if you're referring to something new, I have to stop it before it comes in. If it's already in the bundle, fine. Maybe a short adjournment to allow that to happen. He could speak to his colleagues; they might be able to assist him. But also, could we, whilst we have the 5-minute adjournment, if there's anything else this officer wants to refer to that's not like this or a hint there, show it to me now, and we might be able to stop this stop and start.
That's fine, yeah. If it was going to be quick, I thought it made sense, but if it needs a bit longer, then let's take 5 minutes, and then if you can highlight the pages and provide them to Mr. Dadds and anything that you are going to reference, if that's okay. Thank you. Yeah, look, we're just coming up to almost 8 o'clock, so I'll do it until 8:05, just round number, makes sense. That'd be great. Thank you. Sorry, we're just going to take one extra minute, if that's okay. There's people coming back from both sides, I think. I don't know how we. I think we've got one missing. I don't know. Yeah, just one more. Okay. You're all right. Yeah. Okay. If everyone's all ready, then, if happy to proceed, Ms. Pullman, is everything okay? Yeah, you're all good. Lovely. I'll hand back to Mr. Wright. Yeah. Thank you.
Thank you, Chair. I'm referring to page 158 regarding the email received by Mr. Bell, and basically I'll just read some of it. Thankfully, we are only honouring the last couple of events as we are changing direction at yet more expense to our humble business. But I've already warned the relevant customers that you would probably object to their wishes. This proposed change of direction would actually be supported by Environmental Health Pollution team, as lower level background music would be played, and this together with the prevention of late night parties would be far less likely to cause noise nuisance complaints going forward. Yeah, that's it. Thank you.
Thank you very much. We'll go to members at the moment and then ask others. Do members have any questions of Mr. Wright at this moment?
No, I will have questions for a bit later. Thank you.
That's fine. So thank you very much. Any other third party who has any questions? Mr. Dadds?
Yes, would you mind for you, please, Chair? Thank you.
Absolutely.
Good evening, Officer. Thank you very much. I'd just like to ask some points of clarification, if I may. Your representation at page 243, it says the performance of amplified music, particularly those that occurred outside normal hours, have resulted in most noise complaints to date. Could you possibly just tell me in the last year how many noise complaints there have been within hours, within the current premises licence, not tens? Because you haven't provided a list. less than 2,300 hours.
Sorry, Mr. Dodds, your mic is on.
Yeah, thank you. I haven't actually got the figures available. What I can say is...
I just want to know how many there are under 11 o'clock. If you haven't got that, then that's my question.
Yeah, I haven't got that available.
Mr. Wright, would you mind turning your microphone off? Thank you.
And it's fair to say that you actually haven't provided any logs or any diaries or anything within your representation at page 243. That's correct, isn't it?
Yes.
No further question.
Thank you, Mr. Dodds. Councillor Gorton, you indicated you wish to ask.
Thank you, Chair. Through you, Chair, if I may ask Mr. Wright, in your statement about the events of the 18th of October, you say you arrived at 22:15 and was met by the... Sorry, let me start again. You noticed noise from the lounge wine bar as I approached, and you arrived at 22:15 and was met at the front door by the occupier. We went upstairs into her flat. This is the flat opposite the lounge wine bar, I presume. You say, I could hear noise from saxophone, people talking and singing, and also from amplified music. Noise was witnessed from all areas of the flat, with the kitchen window both open and closed. I attempted to record the noise using the council's noise recorder. Took a 3-minute recording. Level was fluctuating at 39 decibels. In your opinion, is that level of 39 decibels excessive?
In my opinion, no, that's not excessive.
Yeah, please do.
Thank you, Chair. You also gave it a 5/6 rating out of 10. That is, I presume, a subjective rating.
Do you mind turning your microphone off, Councillor Gordon?
Yes, it is.
Can I come back once more?
Please do.
Then you say you walked across the alleyway, met the occupier at the front door and went upstairs into the flat directly above the lounge wine bar. Again, noise was witnessed from all areas of the flat at a slightly higher level. 6 to 7 out of 10. Having removed, that's not relevant. You noticed the floor, right? You say you noticed the floor vibrating in time with the music. Do you consider that the level of noise in the flat above the wine bar was excessive? Thank you.
I don't consider it was excessive, as in my notebook I've made a note to say basically that although I could feel the floor lightly vibrating through my socks in time with the music, we were able to hold a conversation in the flat at the same time without raising our voices.
Thank you.
Councillor Wagland.
Thank you very much indeed, Chair. I wonder if I might just ask, and I fully appreciate that we've had evidence, but did I hear correctly that the evidence was of dB, as in decibel, and the figure is 39? Is that right? Could I just clarify with the witness?
Do you mind your microphone?
Yes, there was 39 dB was the reading. It was fluctuating between about 38 and 41 dB while I was there.
Sorry.
Don't have a figure for the figure over the ambient noise. I thought the correct approach was a dBA, and that would have been presumably less than the decibel. I take the witness has nodded, if I may say so. So the relevant figure would have been less. Thank you.
If you can confirm that, Mr. Wright, if you don't mind, if you're able to, yeah.
I'm sorry. Can you just repeat that, please?
Sorry, myself or Councillor Wagland? Are you asking me to repeat, or Councillor Wagland? Councillor Wagland, would you mind repeating what you said? And I just want to make sure that it's on record properly. I know that
the figure given was, we've confirmed, the witness has confirmed, was a decibel level. The relevant figure, as I understand it, is at what's called dBA, which is decibels above the ambient noise level. We do not know what that figure would be, but it would inevitably be a lesser figure in this context than would be a decibel figure. It merely makes, I think, more of that particular point, but I'm surprised that we didn't have that as a piece of evidence, because I think that's what I would have expected.
Okay, thank you.
Yeah, the level of that was playing was actually recorded live at the time, and that's it was fluctuating at around 39 to 41 dB. That's it.
Sorry. Okay, Mr. Wright. Mr. Dadds, you wish to?
I don't know what the council is asking, but I'll ask the question just in case there's any uncertainty. Officer, did you check what the ambient temperature at...
Decibel.
Sorry, ambient noise, not temperature. I'm thinking about food, sorry. Because I normally deal with food after 11, sorry. Dealing with the ambient noise at 10, 15 or thereabouts, did you take any measurements in the high street to see what the ambient noise was?
No measurements were taken in the high street at the time, no.
My last question at this stage, so it's absolutely clear that there's been no noise abatement issued, no noise abatement notice?
No, there hasn't, no.
Mr. Leonard.
Could I just ask one question? Do you know how many noise complaints you've received over the 2-year period at the premises, irrespective of what timescale it was?
Yes, we do. We have received 30 noise complaints from 9 complainants since the Wine Lounge Bar opened.
Yeah, I'll just make an observation that that's the licensing authority asking a question, and the officer's got his answer there in his log. That should have been given, I think, in advance. It does prejudice us because I can't question upon it or get the details, but I'll address you appropriately on weight later about that answer and why that was layered in that way.
Councillor Russell.
Thank you, Chair. Yeah, my question was about noise abatement. David, Dad's asked that question, but you say there'd been various complaints about this. Usually, we ask residents to diarise events before we end up, going out and investigate them. So my question is, have those events been diarised, which then actioned you to go out and investigate them? And by the way, if it helps everyone, my decibel meter has been reading this meeting between 45 and 66 decibels.
Despite sending out an awful lot of diary sheets, an awful lot of complainants, none have been returned today.
Okay, thank you very much. Unless there's any more questions, we shall move on. All good? Thank you. With me. We'll now hear from other persons present who've made representations. First up, Councillor Hugh Gordon.
Thank you, Chair. My role... Sorry, Chair, can I just clarify before I start? How long have I got?
I'm being quite generous to ensure that everyone has their right to air all of their issues. So,
Could that be directed to the page number of the agenda, because that will, I expect, limit to some degree, because you can only speak to what you've written. So I wonder whether I could just be clarified what page number, because it's not full council, it's not speech, it's only to talk about what you've already written. It's 248. Councillor Gordon.
Councillor Gordon, yeah, 248.
Thank you, Chair. My role as a ward councillor is to represent the interests of both residents and business owners in Ingatestone. I want to see a high street with thriving independent businesses and a place where residents can live in relative peace and quiet, near to shops, cafes, restaurants and pubs. Since the previous licensing hearing in August 2023, the licence holders have made a success of the business. The bar has become a favourite place for many locals to have a coffee or a glass of wine and a snack or a meal. It is also the venue for many community events. But problems have arisen. Problems that amount to public nuisance from what I've read and heard. That's why the licence is being reviewed at this hearing. The officers' reports detail these incidents, and I have summarised some of them in my written submission. These problems are largely due to excessive noise from late-night music events at the bar. Residents are protected by law from excessive noise that unreasonably and substantially interferes with the use or enjoyment of their home. Noise after 11 p.m. can be considered a nuisance, particularly if it is regular and intense. Prevention of public nuisance is also one of the aims of the Licensing Act. I would contend that this has arisen partly from the conditions of the licence not being adhered to. One condition applied at the previous hearing was removed in October 2024. It required the windows and the doors to be kept closed after 6 p.m. The remaining conditions require that the external area to the rear is cleared of patrons by 8 p.m. on Sundays to Thursday, or 9 p.m. on Friday Saturday and bank holidays. After these times, windows and doors must be kept closed. A breach of the conditions occurred on the Thursday, the 10th of October, when the Rapstars fast food van was parked at the back of the premises until 10 p.m. and the back gates were left open to let customers from the bar buy food from the van. 4 complaints were received on this occasion. Late night music events held under temporary event notices, TENS, have been a large part of the problems. Take, for example, the event on Saturday, the 12th of April, when the bar was allowed to open to 1 a.m. and a DJ was playing. Licensing and environmental health officers were on the scene and they could clearly hear the music from outside the community centre, some way up the street. The front door was propped open and up to 20 people were milling about outside. A young man was urinating in the alley at the side. Taken together, these clearly add up to public nuisance. In their latest incident on the 18th of October 2025, the 10 was not approved because the environmental health officer had objected to it on the grounds that the management were not effectively controlling the noise from the premises. However, the event still went ahead, resulting in the environmental health officer monitoring noise levels in both the flat on the opposite side of the alleyway and the flat directly above the premises. Now, what I was going to say is levels in both flats were excessive, and I still believe that to be the case. With the floor in the flat above the premises vibrating in time with the music. That doesn't happen unless the noise is excessive. I'm not calling for the licence to be revoked, but I am calling for the conditions of the licence to be strictly adhered to. That means the external area needs to be cleared by 8 p.m. or 9 p.m. on Fridays and Saturdays. It also means closing the premises at 10 p.m. or 11 p.m. Thursday to Saturday. But there was a blatant breach of the licensing hours on the 18th of October when the environmental health officer observed that the music was still going on at 11:40 with no TENS in place. As I mentioned earlier, the problems with the noise disturbing the neighbours happen when there's late night events held under TENS. I would like to see no more TENS issued until the environmental health team are satisfied that the neighbours are no longer being subjected to excessive noise from music nights and no more complaints have been received. Better sound insulation could be installed and a noise limiter fitted to the sound system to help achieve this. I would also like to see the way the licence holders interact with the immediate neighbours improve. Putting up misleading notices about taking photos from outside, moaning about them in YouTube podcasts and threatening to sue them, as happened the day after the latest incident, is not professional and not the way to conduct a successful business. Please take their complaints seriously and address the public nuisance issues that have repeatedly occurred. Thank you.
Thank you, Councillor Gorton. Next on the list is Councillor Jane Winter. Councillor Winter.
Yes, that's me. I'm a member of the Planning and Highways Committee of Ingatestone and Freining Parish Council, and I'm speaking on the committee's behalf. The Parish Council is particularly concerned about the ongoing issues for local residents in relation to the licensing objectives under the prevention of crime and disorder, and the prevention of public nuisance. The Parish Council notes that the licensing subcommittee granted a variation to the premises licence with the conditions agreed with Environmental Health and the police on the 2nd of August 2023. The committee further resolved to grant the following conditions after consideration of representations made by all parties. That the external area to the rear to be cleared of patrons by 2000 hours, Sunday to Saturday to Thursday. External area to the rear to be cleared of patrons by 2100 hours, Friday and Saturday, and this will include bank holidays. Late night refreshment is not included in this licence. To increase the sale of alcohol by 1 hour to 2200 Sunday to Wednesday and 2300 Thursday to Saturday. Windows and doors must be shut after 1800 hours and remain closed. The committee resolved to grant the amendments regarding further hours as per the initial application. These licensing conditions were altered on the 2nd of October 2024 in relation to the windows and doors which had to be closed after 1800, changing to a condition that all windows are to be closed when the garden area is cleared of patrons, 2000 Sunday to Thursday and 2100 Friday to Saturday. A similar condition was applied for doors to be kept closed after these times, except for access and egress. This relaxation has resulted in more complaints from residents. The Parish Council is aware of the monitoring arrangements for these conditions by the Licensing and Enforcement Departments of Brentwood Borough Council. The Parish Council is also aware of the incidents where residents have requested enforcement of the licence conditions and understands that advice from the Senior Planning Officer is still to be actioned by the bar management. The Parish Council asks that the Borough Council officers enforce the licensing agreement so that residents may have confidence in the regulation system and that the Lounge Wine Bar continues to serve its patrons successfully.
Thank you, Councillor Winter. First off, do members have any questions of any of the objectors?
No. Okay.
Councillor Gorton?
Can we also include Councillor Sankey's?
Well, Councillor Sankey's not here, and we have had this sort of raised earlier on. There is a representation from him in the agenda. So
I know, but he would have been here if it wasn't for a family medical emergency, and he has supplied the text of what he would have said tonight had he been here.
Mr. Adams.
I think, Chair, we've not had any notification from Councillor Sankey. He's asking anyone to represent him. So I think, in fairness, probably just his written representation should stand, unless my legal advisor feels differently. But we haven't received any notification of him asking someone else to represent him.
Thanks for that. Sorry. Councillor Gorton.
As I said, this has arisen as a result of a medical emergency.
I think it's. I realise there may be sort of extenuating circumstances, but I'm conscious that I guess if there's a procedure to be followed whereby the person is officially notifies us what's happening, then I think we should stick with that. Sorry about that. But, do any other parties have any questions of those making representations? Mr. Dance.
Yes, can I just ask the gentleman of the council, I know that there are other interested parties. I don't know whether you're just dealing with the objectors, in effect,
It's objectors at the moment, and then we then move on to the supporters.
Super. So I just want to ask the councillor who spoke first, the gentleman, that I wondered whether he could just confirm that he says in his representation, through your chair, that his view is made because of what he has read and heard. I don't know where he's heard it, but does he accept? I want to ask the question: has he been in attendance at any time and made a complaint to the licensing authority? Because I don't know if he lives within the vicinity. If his representation is based on the papers we've already read, I just want to clarify it's hearsay. That's all that we've got from the councillor.
Councillor Gordon.
No, I don't live in Ingatestone. I have had conversations with one of the near neighbours. The rest of what I've said is very much based on the officers' reports. I think they give a pretty full picture of what has been happening over the last 2 years. I shall leave it there.
Part of my question was that has he in the last 12 months written to the licensing authority or Environmental Health raising a complaint that he has been made aware of or witnessed himself?
I haven't made a complaint as such. I have exchanged emails on some occasions with licensing officers.
Mr. Thatcher, yeah, you're happy with that? Okay. Thank you very much. So, any further questions of the objectors? No? Okay. No. Sorry, what?
Can this gentleman introduce himself?
Yeah,
Sorry.
yeah, I know you did. You introduced yourself earlier, but
Chair, just for clarity, the gentleman has made a representation, so potentially should be entitled to ask a question if he wishes.
yeah. So.
Chair, what I've done is I've agreed with
It's Mr. Barnes.
I speak on their behalf and ask questions on their behalf, so I actually think the gentleman does want to ask a question now.
Okay. So, but isn't going? But then it's up to the gentleman, isn't it? I guess it's. Yeah. Okay. So just to be clear, if you wish to ask the question, you're welcome to. If you don't, that's fine as well. Okay. Right. So if there's no further questions, we shall move to the supporters. John and Sherry Cavill, if you wish to make your make your representation.
Thank you, Chair. I'd just like to express the hope that this matter can be resolved to the satisfaction of all parties concerned. From what I've heard this evening, that should be eminently achievable, and I hope that that will be the outcome of this meeting.
Thank you for that. Do you both? Is that for both yourself and Sherry? Yes.
Yeah, that will be for both of us.
Thank you. I have then next on the list I have Councillor Wagland.
Thank you, Chair. I do live close to these premises and I know this part of the High Street very well at different times of the day and evening, including using the premises myself, as I've indicated in my representation, which you members already have. I walk past the premises most days and I drive past them at 20 miles an hour if I'm going further afield than I can get to by train. From my regular comings and goings, I've not seen a pattern of antisocial behaviour, people hanging around outside or ongoing noise that I would associate with the way that these premises are operating. From what I've seen personally, and I've put more detail about that in my representation, the premises are managed in a professional and responsible way. And I note that to some extent that is common ground, I think, from with the officers. The staff are trained to de-escalate situations, including awareness of Ask for Angela, that type of social care type approach, and there are supporting responses to vulnerable people or customers with disabilities. I've also seen staff giving patient and practical assistance to those with dementia and to their carers. I was present late evening on New Year's Eve after the fireworks on Fairfield, when the atmosphere was convivial and friendly to all who sought refuge on a very cold evening. There was no sign of antisocial behaviour, and I specifically, having had my attention drawn to the notice on the door about this review, went to have further looks around the alley and on the high street, and there was no noise. Indeed, the community centre, which is much closer, I think, than Councillor Gordon would suggest, was actually on that occasion more noisy from the high street than the situation with these premises. I've personally received hardly any adverse comments, and I would say, in fairness, of course, that they may have gone in the direction of others. I don't know, but I personally have received one, and on the basis of what I've seen locally, and on the evidence that I've heard from this meeting, I am concerned about the fact that we now have common ground which says, as I understand it, and you members will have to decide this, that it's not appropriate to seek revocation of the licence. And that seems to me to follow from what I've heard and from my own experience, that this is an asset to the community and well supported, that's common ground, that the officers want to help this organisation succeed in its business. It appears that there are no issues during the day. Well, I have to say that I entirely agree with. Councillor Gorton and I have both attended meetings right up into early evening and a little later than that. And it's agreed, as I understand it, that there is no remit for behaviour outside the premises beyond what can be achieved. Hence the notices we see in cinemas and other places saying, please go home quietly. And the point that I made earlier, which is that I don't think you have any noise evidence to support the concerns. This worries me greatly and is consistent with my general impression from my own experience. But it does seem to me that you haven't got any evidence of what the ambient noise is. You haven't got any evidence of decibels over and above the ambient noise. You haven't actually got anything other than a pure decibel level, and I think Councillor Russell just indicated why that would make no sense. And there appeared to be at each question an acceptance that the noise was not excessive. So it seems to me that this is a situation which is really one where neighbours and operator are struggling with the fact that they sit side by side. And from my point of view, it does seem to me that there is a key question about what is actually being looked for. It seems to me that at most what is being looked for are proportionate and targeted adjustments, such as there might be, which might actually make that accommodation more comfortable in relation to those who have objected. So, if I may, that was all I would wish to say. Thank you very much, members, for listening, and I do hope that what I've said has been of some assistance.
Thank you, Councillor Wagland. Next on the list is Mr. Barnes. If you.
Hi. I was going to virtually say exactly the same as that. I fully concur this, but the other observation I'd make is from the Councillor Gordon, was it? I mean, some of the terms you use excessive noise, again, you haven't got any evidence of that as such. You've got a couple of readings. It's not substantial, in my opinion. I'm an engineer. If someone gave that to me in a report, I'd throw it back at them. You've got the phrase used, more complaints. You don't say how many and how many people. You've got community hall is some way up the road. It's virtually opposite. I mean, it really is virtually opposite. I don't understand this sort of approach. And then you've got the word blatant breach. It's just a breach. It's paperwork that can be sorted out, I'm sure. And, you know, if you want to see another charity shop or a boarded up building, you know, I think that's the way to go. But it's really bang out of order, really. I mean, I think it's such a good community hub. It's a good thing for the high street, and it's the right thing for the high street. Thank you.
Thank you, Mr Barnes. Do members have any questions for those making representations?
Voting for Mr Dad's, what would that come under that?
You can ask him shortly, I think.
Oh.
He'll make his representation. He'll speak in a moment. Yeah. No. So no questions from ourselves. Do any other parties have questions of those making representations? No. Okay. Sorry, Councillor Gordon.
Yeah, can I just come back on a couple of comments made?
I'm afraid it's questions, Councillor Gordon. So you can ask questions of the speakers. It's not points of clarification or anything like that.
Well, I feel I've been
You will have a chance to sum up later with some, with points about stuff. Yeah. We'll now hear from the licensee's legal representative, Mr. Dadds.
Thank you, Mr. Chairman and members. Honestly, I'm at a loss where to even start, to be honest with you. I've never seen a review like this. I've been reading it yesterday and today, and I'm at a loss of why I'm here. Also, I'm here, I'm being instructed. But I'm going to say why. The licensing authority have confirmed today, this evening, that as the responsible authority, they've only visited once in the last year, the premises. And only once when they observed a temporary event which was running, which they say in their opinion was noisy. There's been no other visits on a Friday or Saturday or any other trading day in that year. They've also confirmed that there's been no warnings, hence no cautions, no prosecutions in the last year either. They've confirmed there's been no interviews under PACE in the last year. The licensing authority bring this review on grounds of, that's right, the licensing authority bring this review on grounds of crime disorder and public nuisance. Let me take it in terms. Grounds of crime disorder, the officer has confirmed they don't investigate crime. They don't look into crime disorder, they're not the police. Essex Police have not joined this review and don't join the review. The statutory guidance reminds you that the police are the main source of advice on crime disorder. They are not here, that is material. The case of Daniel Thwaite tells you you have to have regard even to the matter that if the police are not here, you have to take that into account. Because they'd be duty bound, I would say, to raise an objection if they felt that there were issues arising of crime and disorder. The licensing authority have done nothing further than that. They are regulated under the Regulators Compliance Code, taking a graduated approach to enforcement. No interview, no informal interview, no PACE interview, no action plan, no written warning, no caution, nothing. Just frustration, perhaps, that a 10 was undertaken or operated without an authorisation, and a rush to show strength. As I think in Hamlet said, it's great to have the strength of a giant, tyrannous to use it as such. On public nuisance, the officer confirms he has no professional qualifications on public nuisance, and likewise has said that he is not the person responsible for investigating noise complaints. In any event, in the year, it's only attended once. He brings the review. Outrageous. Completely against the Regulators Compliance Code, against the spirit, I think, of this council, is to work with premises who are maybe undermining the licensing objectives, not following the conditions, taking a graduated approach. Not getting involved with tittle-tattle from different neighbours or councillors in his ear. It's an asset to the community. He says he wants to help, wants business successful, no issues during the day. I'm repeating what the councillor said. She made a fantastic note. The Environmental Health Officer, who joins the review by way of a memo and a note, which we've all seen, which is quite scant at page 243. Page 243. No complaint logs, no diary returns from any resident, no witness statement of observations within the terrace or the terrace cottages, no witness statements from the resident above or the resident across the road, no logs, no recordings, nothing at all. In fact, I welcome the officer's evidence. I think he was very professional, very candid and clear. I think he's probably somewhat embarrassed to have to be here because this is clearly not a premises that causes him any concern. Perhaps he wants to support his colleague, and I understand that, but that is wrong, in my opinion. There's no noise abatement notice. There's a reference, partial reference to normally it's matters operating outside of the premises hours that cause the most complaints. In other words, the 10s. The 10s are causing a problem for environmental health, they say. But that's not this premises licence. There's a simple answer to that. Object to a 10. Have a 10s hearing. That's a separate authorisation. If that's causing the problem, going beyond 11, you deal with that with a different statutory scheme. That's not this review of this licence, because you have no evidence from environmental health whatsoever of any matters arising from them and their observations and their logs before 11 o'clock. They've not provided any detail. The question from David Leonard, nicely lined up on the night, how many complaints, and you got the answer. The officer was able to go straight to it. I would say treat that with little weight. We don't want any ambushing at this. I don't know if that's been... I'll ask you that question during the hearing, and we'll hit them with that. No, we don't play that funny business. Ambushing, those days have gone. You need to disclose it in advance and be fair. Because then I would say, well, is there a causal link? What day of the week? What time? Was it corroborated? Was it witnessed? And we know that that's really important. And the reason why we know that is important because we had the complaint in October twice regarding antisocial behaviour. CCTV proved that there was no antisocial behaviour or crime, and certainly no crime linked to the premises. So people calling in, someone's called Essex Police saying that there's an altercation, they turn up, there's no altercation, CCTV viewed outside, no altercation. So some people can make a complaint that is false. So environmental health can't assist you either. So that's the licensing authority, environmental health. Local residents that have objected, they're not here. We've got 30 odd residents here that are supportive, that are here, and your voices will be heard. We've got a paper petition which was in your bundle, and we've got an online petition which you've received of over 700 names. That is overwhelming support for a premises. The new statutory guidance says and guides you at 1.18 about economic growth, proximity in relation to high streets. You've heard about we want a vibrant high street. I know Ingatestone High Street very well. I was very disappointed when the Chinese restaurant closed, personally myself. But I know it very well. I used to live in Dodds Farm, just around the corner, whilst I was having my house refurbished in stock. So I know the high street really well. And it's important to have these high streets vibrant and alive. They are, by its own very nature, high streets, noise generating. We know that through the agent of change principle. If you come and develop or you live near the high street, it is said that they create noise. Businesses generate noise. So we don't live in the world of the councillor that says we want people living in high streets nice and quiet and peacefully. No, high streets are by its own nature noisy, and they will create noise. It's what's reasonable. And I'm pleased with the environmental health officer saying, look, I've gone into the premises, I've done a measurement, and I don't think it's excessive. I don't think there's a breach, because it's on a high street. If that was away off the high street, it might be a different thing. I don't know. The councillor who relies on his own opinion, who's not an expert, has not witnessed it, not been in the flat, has just heard the professional officer say it's not excessive. He says, it's excessive. No, reject that submission. Yeah, absolutely reject it, because that shows a bias against the premises, bias against the evidence, bias against professional evidence, shows an opinion that actually does want to, in effect, cause harm, unreasonably, I think, to this premises, not coming to this as a councillor should come to it, with an open mind. He said at the beginning, he is elected by the residents, he's not elected by the businesses, but whilst he's elected as a ward councillor, he represents businesses and residents. He has chosen to take a side. He should be actually supporting this business, listening to the professional officers and coming to an objective view about the evidence regarding noise. So reject that. The residents that have complained say that they're intimidated by the process. That obviously they can write, they can come here. No one here has actually, you've got lots of residents, no one here has said anything inappropriate upturn. You've got children present. People care about these premises. If they want to be heard, they can come here. Now, if they don't come here and they make written representations, you are guided by the case of East Gwent that says what weight you attach is a matter for you. But actually, in Patterson's licensing laws says it should be either little or no weight, because the make of the statement is not present to be asked questions of. And that they have been given diary sheets that they've not completed, they've not returned, there's no corroboration of their complaints, officers not been in the premises and provided any evidence. We know, as you've heard in evidence from the get-go, they did not want this premises. I would submit the local residents did not, and the cottages behind, except from the lady that sits behind me, did not want this to be turned into a not a drinking establishment, an establishment that allows for food and drink, E-class. And they didn't want that. And they've objected from day one. They've objected to people being outside in the back garden and put a limit on it to 9 o'clock. That's them facing outwards. Facing back, they've got the Budgeons car park, and that going backwards and forward until 10 or 11 o'clock. And they complain about that. It's all very close. Immediately behind that, you've got another block of flats. We've had no complaints from them. the point I'm making with regards to the residents, they're not here. The maker of the statement's not here, and I'd ask you to treat little or no weight to that. And that there's been no other evidence about noise breakout from the premises. The only evidence has been on the Thames, when that maybe the ambient noise is reduced in the high street later in the evening, but it is still on the high street, and those Thames are restrictive. If the Environmental Health or the police believe that they shouldn't be granted because they undermine the licensing objectives, then they have a right to object. I say that that is the focus of this review, if anything, and the licence, as it is, remains unaffected. Tell the licensing officer to go back and do it properly. Don't be afraid to do that, because ultimately the officer should be going back, having proper interviews, proper meetings, keeping of records, having those records, taking a graduated approach, rather than what we have. I can say this quite clearly, that there was my client does respect the council, does respect councillors, respects the local community, and holds the council in high regard. They do not they do not hold Mr. Leonard in high regard. They find him a bully, in effect, because he comes and he intimidates. That's how they see it. And the position is that when they had the issues with the back door, that's when they clashed. And since then, as he says, he's not on the Christmas card list. No, because they didn't deal with it in a practical way. So like a ball in a china shop. The reason that got resolved is because I gave advice for a minor variation, but it was unenforceable, those conditions, because they were tied, I say, in my opinion, to being exempt because they're under the deregulation provisions. Because between 8 and 11 o'clock, as you know, you can do regulated entertainment without conditions. And those conditions related to noise, closing it so no noise escape. But what it meant is that people couldn't go out after 6 o'clock and you had to keep all the doors closed. And even opening door, the way the condition was worded, you immediately in breach. So it was impractical. So rather than trying to find a solution, they were doing this. And that's continued to bash heads since. We need to just draw a line on it. You know, the comments made about the observations of upstairs using the lavatory is just incendiary. It's just not appropriate. Me saying bully is not appropriate. But I think it needs to be balanced. We need to say why we've fallen out with Dave Leonard and why we are here and we should not be here. So it's for your wiser heads to look at the evidence, because the case of Daniel Thwaite says you will look at the evidence. The guidance says you look at the evidence. And remember, it's about looking at the undermining the licensing objectives. I'd like to just do a couple pieces of comments on law and guidance, if I may. I don't think I need to do too much on public nuisance, but the private and public nuisance, the flat immediate upstairs would be considered private nuisance, not public nuisance. And there's plenty of case law about that. But since we haven't heard anyone, I'm not going to do too much on that either. But in relation to the law, of course, this is the first review of the premises licence, and it's held by the Wine Lounge Limited. They have not had any tens. Any determination should be evidence-based, justified as being proportionate for the promotion of the licensing objectives and appropriate to achieve its aims. The statutory guidance which you will follow says that the licensing authorities do not have the power to judge criminality or otherwise. That's a matter for the courts. The licensing authority role in determining a review is not to establish innocent guilt of any individual, but to ensure the crime prevention objective or licensing objectives are promoted. You will see that you will have a look at the matters we've been told that are not going for criminal investigation of the tents, but we would say that we were told or notified good luck and we hope that the event goes well. So there was miscommunication about how that tent was about, but I don't think we need to go into that any further. In relation to the powers you have, in deciding what powers you use, it is expected that the licensing authority, so far as possible, should seek to establish the cause or causes of concerns that the representations identified. The remedial action should be generally directed at those causes and no more than appropriate and proportionate response. It looks like it's the TENS, and that's outside of your scope because that's different statutory power. There's been no, the licensing authority is not to punish anyone. It's obviously a view to promoting licensing objectives. And I've said earlier on, and I'll say it again, it is not for this committee to look at blame. It's not to determine legal culpability. It's not to assign any blame and not seek to punish any party involved. It cannot and does not exonerate anyone or excuse any third party. It must look at the licensing objectives and determine the application on its own basis and facts. In this case, there is a lack of clarity, I would say, in the number and identity of complaints and complaints. There's no clear picture here. It's been an untested source, should be given little weight, and I've referred to the RV Licensing Justice of East Gwent, 1999, 145 JP 339. And in Patterson licensing law, it says the weight to attach to such objections is for the decision maker, but the applicant's right to a fair hearing must be respected. And obviously, where we have a number of small objectors from individuals, and they're not here, I would ask that could even be considered private nuisance, not public. In any event, they're not here. I only have one resident, which is behind me, that I wanted to ask a question, but I'll do it this way. So this lady behind me lives at number 3, the cottage behind, and she has told me that she lives directly behind and that she is not affected at all by noise coming from this premises. I'm just going to ask her if she could confirm that that's the position. Yeah. Yes, the answer is yes. So I'm not going to ask her any other questions than that, Chair. That is my submission on behalf of the premise licence holder, unless I can assist you any further.
We've just come in a little bit quick there. Obviously, you asked someone that I'm just conscious of the fact that whether or not this was in the agenda, was representation made.
She signed the petition, and we submitted that as part of our papers, and she lived directly behind. So that's in the. She signed the petition saying that she has no cause of concern.
Okay. Obviously, it's sort of. I'm conscious that this has come late. Are there any issues with this?
Thank you. So obviously, if someone hasn't made representations, they don't have the right to address the panel themselves. To the extent that one of the parties, the licence holder, wants to call another person to give evidence in addition to their representative, because they haven't given notice more than 5 days before the hearing, they have to ask permission to do that, and that permission won't be unreasonably withheld. I think in circumstances where it's simply being said that this lady lives behind the premises and states that she hasn't received, or she hasn't heard any nuisance or disturbance, it's a matter for you whether or not you're willing to sort of accept that as effectively an indirect request to have some additional evidence out of time. Given obviously she's not made representations and not been able to answer questions, I think the weight that you would give to that is a matter for you.
Thanks very much for the clarification. I think we're okay with this. Excuse me. So, yes, absolutely. So, do members have any questions of the licensee?
Yes,
Councillor
please,
Davis.
Chair. Mr. Dadds, you did sort of touch on the licence issues and restrictions yourself, but talking to you, your clients, through you, do you feel you've always adhered to the terms of your licence on every occasion, and have there ever been occasions that have caused you concern? I've got 2 questions, thank you.
So the answer to that is yes, we adhere to the licence conditions and promote the licensing objectives. No concerns.
Part of the conditions is that you have to keep the windows and doors closed. Now, on occasions where you might have 50 people within the building, is it actually viable that you can do this? And do you have sufficient ventilation within the building? I know part of it is open at the back, but do you have sufficient ventilation that you can safely operate with doors and windows closed?
The answer to that, yes.
Yes to the ventilation or yes to the... Thank you.
Thank you, Councillor Davis. Councillor Russell.
Thank you, Chair. Yes, so part of our functions when it comes to licensing for others here is to evaluate applications against the 4 primary licensing objectives. Could you then outline the specific procedures and measures the establishment has implemented to ensure compliance with the licensing objectives, in particular the dispersal policy? Thank you.
Yes, we have a dispersal policy. That is part of the training of members of staff. They use a system called Licensing Connect, so all the staff receive training through the licensing portal. They have a copy of the licensing dispersal plan, and operationally the premises has a number of notices asking people when they leave to respect others, and obviously they do what they can to make sure that happens. As you are aware, that once people are away from the premises, as a matter of law, they're outside of our scope. And the guidance tells you and tells us that once people are outside of our premises, they are responsible in their own right to be law-abiding.
Thank you, Councillor Russell. Obviously there's questions about the TENS notices. Has anything been put in place as far as you're concerned to try and avoid this confusion going forward, to mitigate these issues, stop them? You're obviously saying that you don't feel you're getting the support from officers. If we're going to stop the loggerheads, how do you feel that can be done on your side, and what are you doing to do that?
Yes, we will give help and assistance on the TENS and advice, and I've done that in part. We have someone in our office who can communicate with Mrs. Bell and Mr. Bell about that. In relation to the comments regarding, there seems to be some sort of criticism about not filling in the form properly, having late TENS, or they're being rejected. That's not a ground for review. If the council's frustrated about members of the public, how they fill in the forms, then that's not a ground to come here and call for a hearing and to admonish them or even criticise them. That is, that's just the process when maybe people even make an application or TENS or anything. But now, your specific question about will we help and assist to try to ease that tension, notwithstanding it really shouldn't even be here in this hearing, we will assist and help, and we will guide on how that is to be completed. So we'll assist. My understanding that the business is moving the parties, or when I say parties, celebration, I like to put it that way so it's not too emotive. There are few and far between, and there are on TENS. Generally, the premises operates within its core hours without any cause of concern. but we will assist them. I want to diffuse that. I have a good working relationship with Mr. Adams. I have a reasonable working relationship with Mr. Leonard, and we're both professionals, and we might have loggerheads, but we're very professional with each other. And we've had a conversation today about, we've got to try to work together to try to take that tension out, whether it be the residents or the licensing authority. I don't think there is really with the licensing authority. I just think that there was a rush to come to a review because of frustration about that 10, and I think actually cooler heads should have prevailed, and we shouldn't be where we are now, to be quite frank about it.
Thank you very much. So any more questions from anything? So we'll now go to other parties. Mr. Leonard.
Thank you, Chair. Obviously, I'll address the statements made against me and summing up. Just in asking a question, it's been pointed out that the premises licence holder is the Wine Lounge Limited, and the issues about tens are individual applicants. I'd just like to ask Mr. Bads, who are the directors of the Wine Lounge Limited?
Sorry, your microphone.
Sorry.
The directors are of public record are Mr. and Mrs. Bell, and obviously they are the company. I'm not going to get into a legal argument, Mr. Leonard, about the structural differences between an individual applying for a user and a limited company who's a premise licence holder. They are two separate. If there is a breach, or not a breach, if there's an offence under the Licensing Act, under section 136, that goes to the user. It cannot be the company, in my opinion.
Thank you, Chair. It's just pointing out the three directors of the Wine Lounge Limited are Mr. and Mrs. Bell and Charlie Bell. That's it.
Councillor Gorton, you had a question or some questions.
I've been accused by Mr. Dadds of taking sides. Yes. That is not true. That is not true. I said in my statement, I'm not calling for the licence to be revoked.
Councillor Gorton, sorry, it's questions.
Yeah. Okay.
If you wouldn't mind.
Okay, my question is then, why did you make that statement?
Because of the comments regarding the environmental health, the professional officer told you that it wasn't excessive, but you went on to say that you felt it was, notwithstanding that you haven't been there personally, you don't live within the ward, and that you were taking your opinion based on what was written. But what it was is that you chose that particular fact not to rely on, but put your own opinion on it, which I say shows a bias against the premises, and I against it. And as a councillor, I would have hoped, with the Nolan principles of openness, transparency, showing good leadership as a councillor, you would have objectively assessed the evidence which is before you, orally and written, and not taken a side which is against the facts, and that is my opinion.
Councillor Gordon, if you want another question.
Can I come back on that, please, Chair?
You ask questions.
Okay. Can I ask why the evidence that has been submitted to the panel from one of the neighbours regarding noise nuisance, quite a substantial evidence package, has not been taken into account? I've listened to all those recordings, and there is plain evidence.
Sorry, Councillor Gorton, this isn't a question.
Yeah,
isn't.
my question is, why hasn't that been taken into account, the evidence pack? Thank you.
I'm happy to answer that, Mr. Chairman. And this is showing that bias that I talked about. It might be what we call a confirmation bias, which is you have a view and you look for evidence to support your view. The view has been that this councillor believes that there is noise nuisance, not based on his own experience, but the evidence of others. Rather than looking at it objectively, he's taken a view that the premises is causing a nuisance based on information which has been provided, which is hearsay. And in fact, it's double hearsay. The make of the statement's not present. Those recordings, we do not know the basis on which they were recorded. We don't know whether information or other noise sources could have been attributed to it. We don't know whether there are other, they've not been corroborated by an officer or an independent person, and the make of the statement or recordings is not present to be tested. And as I say, as a matter of law, what weight, of any weight, should be attributed to that evidence is probably negligible, if any. So that's why I've come to that view, and I hope that the councillor will agree with me that the same.
Thank you, Mr. Dadd. Councillor Gordon, do you have any other questions?
Yes, I do. Mr. Dadds said that officers had only been in attendance on Mr. Dadds said that officers had only been in attendance on one occasion. From the officers' reports, I believe that to be 2 occasions. On the 12th of April 2025 and on the 18th of October 2025.
Sorry, so do you want, okay, thank you, Mr. Dadd.
My assertion, I'll answer it. I think this will be the last question I answer of this councillor. That will be my right. But I said that the licensing officer only attended on one occasion in the last year, which was the 12th of April. I did not comment about how many times the environmental health officer attended, but I accepted from his evidence that when he has attended, he hasn't served a noise abatement notice. And obviously on the occasion when he went to the flats nearby, he didn't observe the noise being a public nuisance. Thank you. Or statutory nuisance.
Thank you, Mr. Dadd. So yes, I think we'll call that there. Are there any more questions from anyone? Before we retire to consider the matter, there's an opportunity for you to make closing remarks. Mr. Adams, have you anything to add for the licensing authority?
I mean, just 2 points from the licensing authority's perspective. Obviously, the options that are open to the committee are contained in the report. I'm not going to go through all of those. You may wish to take legal advice in relation to the impact of the deregulation provisions in relation from the Noise Act in relation to conditions attached to the licence, if that forms part of your consideration. I know Mr. Dadd's mentioned it, but you may wish to, if it's part of your deliberation, just seek clarification on that, because I know it's an area that is relatively new to members in relation to that. But that's all I need to say. Thank you.
Thank you, Mr. Adams. Ms. Leonard, have you anything to add?
Yes, thank you, Chair. Yes, just summing up in that and in response to, I'm glad that Mr. Dadd says that we both act professionally. I've always prided myself on my profession. I don't consider myself a bully. I've never been a bully. Obviously, this question, I've only been visiting there once. I'm sure if I'd only been there once, I couldn't have been called a bully. I've visited there more than enough times, which I said in my statement, to go through things, which, in my opinion, is graduated response. I'm bringing this together as a result of something that's been going on for 2 years. The straw that broke the camel's back, as we've said, is this business about, is it a 10, is it not a 10? There was no 10 in place. and they operated after the conditions of their licence. That's what's brought it to a head, and obviously the information that came as a result of that, viewing the CCTV, the questions and answers were done. I'm sorry that it was bad language, but it wasn't me that used it. As I said, with regards to this, it was a graduated response in my view. I've also said that the backdoor business that was going on in the early stages, a lot of that was petty and frivolous. I won't deny that, and obviously I put that to anybody that made any complaint to me. So in respect to that, I think I dealt with that proportionately and fairly. I didn't bring a review, I didn't take it any further. I took into account the problems that the family were having, and I feel that I've worked above and beyond to try and work with them. I would argue that, again, if you look in the statements and the additional letters that I put in, virtually every single one of them, when I've gone to try and, again, my job is to regulate, educate, and then, if all else fails, enforce. Now, obviously, I've gone on the first few occasions over the years to regulate and to educate them in regards to what's required and how you deal with tents and all the things there. I've also put in every single letter that I've responded to on this in a practical and fair way and not a bullying way. If they've got any difficulties or problems with that, seek the professional advice of a licensing agent or indeed someone of Mr. Dadd's stature. And what we are in here is, as I said, in regards to that, this is a culmination of things that have built up. I do hope, albeit that these people haven't attended, the statements there are quite compelling, albeit they haven't been challenged. And I would ask that you do take that into account in some way, because these people live with the situation 24/7. We all go home at the end of the day. So I think, obviously, at the end of the day, with Mr. Councillor Gorton being challenged, I think it's in everybody's interest, and the whole idea of this was not to prosecute them as we could have done, but it was to get a pragmatic response here so that everybody can have their say, those that support it as well. What I would say is, when I've gone on a number of occasions I have gone, invariably I've been the one that's been challenged by the family, and it's always ended up with, we're going to seek legal advice. Now, as I said, I've not done anything to bully, I've not done anything to try and put them down. I've tried to work with them for 2 years. Obviously, it gets to a stage where there are criticisms of the council. If we're not doing our job right, absolutely, they've got a right to put a complaint in, as have any members of the public. I'd like to think that I've done my job pragmatically and graduated across a period of 2 years. And as a result of that, and just as a final note, with the good luck on the template, just to explain to you the process with a temporary event notification. When a notification is received, we have to acknowledge it on the day it's received. So we acknowledge that. And the template that was drafted was actually in the days when I used to respond to them, and I was the one that put good luck on the templates to anybody that applies for a tent, because obviously we wish them well. I don't wish to bully them. I hope they have a good temporary event notice. What happens after that is that there is then a 72-hour period where the responsible authorities, that is the police or the Environment Health Office, have an opportunity to respond to the temporary event notification. And if either of those or both of those object to it and say they're not happy with it because of the circumstances, as has been said, if the temporary event notice is applied for in plenty of time, i.e. more than 10 working days notice, we've got an opportunity to go to a committee hearing where it can be discussed and all that avenues are spoken. Invariably, the number of the tents that came in with regards to the lounge have been late ones, so if there's been an objection to them, there is no grounds for appeal. It is rejected, end of story, and a counter notice issued, or a notice has been issued, which has been done. In this case, for the events of the 18th of October 2025, which brought all of this to a head, both the police and the Environment Health objected to that temporary event notice, hence the reason it was rejected. It was a late temporary event notice, so therefore there was no case for appeal, and as you'll see in my notices, there was plenty of communication backwards and forwards between Mr. Wright, Mr. Michael Bell, and I think it was very, very clear between those letters that the temporary event notice was not supported and it shouldn't have gone ahead. So just leading up on those things, I feel that, as I said, it's not bullying. I followed it through in a professional manner, and at no point have I bullied. The good luck has been to anybody that goes for a 10. On this occasion, it was refused, and therefore it didn't go. It shouldn't have gone ahead. The only other point I say on this one visit, it isn't one visit, it was one enforcement visit on the 12th of April, and I made my comments, my observations. The reality of it is I've made a number of visits there during the course of the day, and I've had no issues with them at all in the course of the day, because during the day they run a very good ship, and I mean, I've been in there on occasions where it's packed and it's been like a library. People are in there enjoying it, and I've got no issues with them at all trying to achieve what they're trying to achieve. But as I said to you, at the end of the day, I have received complaints with regard to that. Environment health complaints are referred to Environment Health to deal with. I don't deal with those. I deal with the stats and with regards to the conditions attached to the premises licence. That's my role in that. And over a period of 2 years, I've worked with the Bells to try and help them go through that. On the specified occasions that I have noted, obviously they have breached the conditions that are attached to their licence. End of story. I think that's about it, Chair. As I said, we have taken this very seriously with regards to this, but it wasn't bullying and it wasn't a knee-jerk reaction. This is a culmination of 2 years of trying to get the Bells to work on board with us. As I said, every time we speak to them, they wish to go to a solicitor. I'd like to think if they actually did go to a solicitor, then they wouldn't continue to make the mistakes they were making. But as I said, hopefully at the end of this meeting, we'll all go away reasonably happy, even if we're not on Christmas card lists. Thank you.
Thank you, Mr. Leonard. Mr. Wright, have you anything you wish to add?
Yeah, I'd just like to say that the majority of the noise complaints that we received was a result of tens that were taking place. And if the lounge wine bar are going to change direction, then we would definitely support that.
Thank you, Mr. Wright. Are there any other persons who have anything to say? Any of the supporters or objectors who wish to speak? No, thank you. Finally, Mr. Dadds, have you anything to add?
Yes. The final word. I thank the Environmental Officer and officers for setting out quite succinctly and clearly to you that there's no statutory noise nuisance, in effect no public nuisance, no evidence of any noise nuisance other than the representation has been made. There's no evidence of that. I think that they make it quite clear that the primary complaint or complaints have been around tens, and tens sit outside of this licence. They're separate authorisations by individuals or users, albeit in their individual capacities they might be a director, but that's separate. As an individual user, they apply for the 10, they get granted the 10. If there's a problem with the 10, then you go back to the user. That's how it works. But in any event, we shouldn't be calling a review of a premises in relation to matters arising with tens. They are separate. And if there's an issue with 10, you just don't get the next one unless you build up that trust or confidence that you can show that the licensing objectives will be promoted by the extended hours or the tens. So I think it's quite separate. In relation to the residents, the makers of the statements, as I've said, if they're not here, what weight you attach would be a matter for you. I invite you to have little or no weight because the makers of statements are not here and we can't challenge them, and in fairness to us, then I'd say that that's the position. You've got residents that are in attendance, you've got 30, they haven't made all representations, I know, but lots of them have signed the petition. I think all of them pretty much have signed the petition. And that you've had hundreds upon hundreds of people supporting the premises through petitions and alike. In relation to Essex Police, they raised no objection, the Planning Authority raised no objection, and no other responsible authority raises objection in relation to this application other than the Licensing Authority through its application for review. The Licensing Authority have made it quite clear that within the last 12 months, there's no warnings, no cautions, no base interviews, no informal interviews in the last 12 months. They raise matters beyond that 2 years, but as you will be aware and you'll be advised that under the Licensing Act, any breaches of the Act need to be prosecuted or brought forward within 12 months as a statutory limitation period. If someone is being accused of a criminal offence, they're innocent until proven guilty. That's a golden thread within our legal system. Individuals are able, through the Licensing Act, a defence of due diligence. And obviously, if there was a prosecution, you could avail yourself of a defence. If it's not prosecuted, you can't avail yourself of defence. So on that basis, anything outside of 12 months, I say you shouldn't take into account or consider. In relation to the last 12 months, as I say, only one visit from the officer. Look at it this way, this is how I see it, I think put in a nutshell. If the officer's only been once in the year through operational and never been on a Friday or Saturday and not written any warnings or complaints, then other than getting late 10s, why putting a review? Now we know why, because he said it himself just a minute ago. The straw that breaks the camel's back was the 10 being used in effect, and he took that as a front in effect to his authority, and so he used his authority and put together a review. He says, oh, out of the kindness of his heart, he did it rather than prosecute. But had he prosecuted, we would have had a defence. Because the licensing authority, when they received the 10, they said, good luck, we hope the event goes well. You know, great. Well, don't put that message on there if it's going to confuse the public. Yeah? And if you're going to send a counter notice, make it clear in that counter notice that previously we told you good luck, but now we're saying to you, sorry, bad luck. Yeah? You've got to make sure that when you're communicating with the public, as a prosecuting authority, that your words and language are clear. If there's any ambiguity between it and it's not clear, it goes as a matter of law in favour of those accused because of that, because of the responsibility to make your language clear. The council said that they will not, as a prosecuting authority, will not be seeking prosecution of that 10. And I welcome that because I think that they would be in a bit of a sticky wicket. However, so in the year, one visit, no warnings, no cautions, no other matters arising, only the 10. And that's been said that it's not in the public interest to pursue it. That's it then, isn't it? Or go home? I know you've got to make your decision. You've got to sit there for a while. I do apologise. But the thing is that we do promote the licensing objectives. We're a really good business. We're a brilliant business on the high street. We're supported by hundreds and hundreds of residents. We're trading every week. We're employing people. We're adding to economic growth. We pay our tax, our VAT, our council tax. We are a good business. There's no crime and disorder, and we say there is no public nuisance. I'd ask you that you don't take any step. Advise the parties to try to be a bit more cordial with the 10s, but because this is mainly around 10s, that's a separate matter. You can't find criminality, you cannot find blame, you must look at about undermining the licensing objectives. On that night, there was an allegation of a crime, which after an investigation showed that there was no crime. So there is no crime disorder at this premises. I say no public nuisance, no evidence of public nuisance. Therefore, there's no steps that you need to take. That is the submission on behalf of the company, the Premise Licence Holder Chair, members, and thank you for your time this evening.
Thank you, Mr. Dadds. We'll now retire to consider our decision. I'll ask Miss O'Leary, our legal advisor, and Mrs. Borman, our clerk, to join to help us with the wording of our decision. Thank you. Right, thank you everyone for your patience. I will now ask Ms O'Leary to read out the committee's decision.
Thank you, and sorry for keeping you all waiting. I should say with the caveat that it's very late and we're just as tired as everyone else. So final reasons will be sent out in writing within 5 days, and we will double check things like dates and names before we do so. So if any little details like that are incorrect, please don't worry. So the licensing subcommittee has considered an application for a review of a premises licence in relation to Lounge Wine Bar. The application was made on behalf of Brentwood Borough Council by David Leonard, acting as licensing authority. And decision was made at a hearing convened on the 27th of January 2026. The licensing subcommittee has considered the licensing objectives, in particular the objectives of preventing crime and disorder and preventing public nuisance, also the guidance issued under section 182 of the Licensing Act 2003 and the Council Statement of Licensing Policy. The subcommittee has considered all formal written representations made to it by the licensing authority, Environmental Health, the licensee. By my count, 9 other persons in support of the review and 4 persons in opposition to the review. In addition, the subcommittee carefully considered the additional evidence provided ahead of the hearing by objectors, which included some additional representations and recordings, and by the licence holder, including various petitions of support. The subcommittee notes that no party in attendance at the hearing tonight invited the panel to consider revocation of the licence. All parties in attendance appeared to agree that this would be a disproportionate step, and the subcommittee agrees with that position. The subcommittee therefore considered whether other lesser steps should be taken, including addition or removal of licence conditions, or the modification of existing conditions on the premises licence. However, for the reasons given below, which I will read out, the subcommittee has decided that on this occasion, it would not be justifiable to take any steps, and therefore the review is dismissed. So the reasons, the subcommittee was satisfied there have been occasions when licence conditions and regulatory requirements were breached at the premises. And this includes A, breach of the licence condition in October 2024 when a taco van was parked at the rear of the premises, meaning the garden was not cleared of patrons nor the doors kept closed after 8 p.m. Advice was given on that occasion, and there is no evidence that this specific breach has been repeated since then, or no evidence before the subcommittee today. On 18th of April 2025, the committee was satisfied Mr. Charlie Bell, when approached by officers during a visit, was unable to produce a copy of the 10 acknowledgement letter, which should have been available upon reasonable request. However, the licensing authority did not pursue this point upon the review, and therefore it carries limited weight. On the 18th of October 2025, the subcommittee was satisfied the premises continued in engaging in licensable activities after 11 p.m, although it did not have a 10 in place which would have permitted it to do so. Without making any findings or comments about upon whether this amounted to a criminal offence, and if so, who, if anyone, would have been responsible for that offence, it is noticed that the premises did operate outside the boundaries of its operating schedule when it was not permitted to do so. On the 21st of October 2025, during a visit to the premises, the subcommittee was also satisfied that management were unable to immediately provide an incident log and records of staff training when requested by officers, but it was conceded during the hearing by the licensing officer that he did not consider this to be a serious breach, and he did not ask for it to be considered as part of the review. On the prevention of crime objective, it is noted that Essex Police has not made written representations or attended the hearing. The licensing authority confirmed during the hearing that it had no intention of commencing a prosecution in relation to the events of the 18th of October 2025. And although alleged crime was reported to the police on a number of occasions, CCTV from the premises appeared to show that these reports were not substantiated. Therefore, on this occasion, the subcommittee was not satisfied there was evidence to find that this particular licensing objective was being undermined. As for the licensing objective of public nuisance, the subcommittee considers that if the reports and complaints of noise nuisance emanating from the premises and their effects on residents were substantiated, there would be cause for significant concern. However, the position at the hearing was that the environmental health team could only provide limited evidence of noise nuisance, and Mr. Wright conceded under questioning that he did not consider the levels of noise he had recorded at neighbouring homes to be excessive. I think that's the 18th of October 2025. There was an absence before the subcommittee of independent or verifiable evidence of noise, such as diary sheets, logs, recordings from responsible authorities, or other verifiable or independent evidence of what has taken place. Whilst the representations by residents in support of the review did make reference to long-standing noise issues and they did exhibit some recordings, those residents did not attend the hearing and their evidence could not be tested by questioning. The subcommittee takes into account that some residents reported feeling intimidated by taking part in the process, and they alleged they have been intimidated by persons connected to the business. Whilst taking that into account, but without making findings on those allegations, the subcommittee nonetheless considers it did not have sufficient evidence to be satisfied that noise nuisance is taking place, or to what extent it is taking place, or what measures could be taken to mitigate it. And therefore, in those circumstances, it cannot presently be satisfied that it is justified or proportionate to impose additional licence conditions upon the business. But this should not be construed as a finding of fact that noise nuisance has not occurred. The subcommittee notes that responsible authorities or other persons may be in a position to request a review with further or better evidence if circumstances change in the future. Finally, the subcommittee notes that the evidence which was available suggests most of the noise complaints appear to arise late in the evening and in particular after 11 p.m. when TENs are in force. In those circumstances, the subcommittee encourages the responsible authorities to consider making proactive use of the TEN process to object to the use of a TEN if it is reasonable or justified to do so. And in the subcommittee's views, at this stage, that offers a less intrusive and more proportionate means to attempt to address problems at the premises before amending licence conditions. The subcommittee wishes to urge all parties, including the owners, management and staff of the business, local authority officers and other responsible authorities, and neighbours and residents to actively work to try and improve their relationships and to reduce the tensions which are evident in this neighbourhood. The subcommittee in particular urges the licence holder and the business to continue all efforts to review and comply with their licence conditions and other legal obligations, to submit further applications for TENs in good time so they can be discussed with responsible authorities and if necessary reviewed so that suitable conditions could be imposed rather than having to object the application for a TEN out of hand, to continue providing training and education to staff and to take reasonable steps to mitigate any possible noise nuisance, including considering commissioning a noise management plan. And the applicant and anyone who made relevant representations in relation to this review have a right of appeal within 21 days. So that will follow in writing within, I think, about 5 days. So.
Thank you very much, Mr. Chair, for that very reasoned decision, and our council will obviously take that all into account and work with the
Thank you, Mr. Dodds. Thank you, Ms. O'Leary. So that concludes our business today. Thank you, everyone, for your attendance.
Thank you, everyone.
Thank you.